Hi friends, today we are going to talk about Article 13 of Indian Constitution, which speaks about the laws which are inconsistent with or in derogation to fundamental rights given in the Indian Constitution. Well, you must know that Article 13 is not retrospective in nature, means it speaks about the inconsistency of any act which was prevailing at the time of passing of Indian Constitution, and it says that those acts which are in contravention to provisions of Indian Constitution or which are inconsistent with the provisions of Indian Constitution, they shall be void. But it is not retrospective in nature, means whatever acts who those were implemented and the decisions made in the litigation in the court of law according to those acts, that will remain unchanged. So this article says that this inconsistency or this voidness of such rules and acts which are in contravention to Indian Constitution shall be effected from the date of implementation of Constitution, and things before that remain unchanged. So the same thing is said in the part 1 of Article 13, which says that all laws in force. So it talks about laws in force, which is further defined in section 3b of Article 13, which we will see later. So as of now, you understand that all laws in force means at the time of implementation of Constitution, whatever laws were there in the picture in territory of India, immediately before the commencement of Constitution, insofar as they are inconsistent with the provisions of the part, shall be to the extent of consistency be void. So this says, if you break this article 13 part 1 into parts, you'll come to understand the first thing it says laws in force. So what is laws in force? In the same article 13 in section 3b, the laws in force is defined as the laws passed or made by legislature in India before commencement of the Constitution and not previously repealed. So laws in force, when we speak about laws in force in respect to Article 13 part 1, it talks about those laws and acts which were present or which were in force in India at the time of implementation of Constitution. So keep in mind it talks about those. So 13.1 says all such laws within the territory of India at the time of commencement of Constitution, or it says that immediately before the commencement of Constitution. So all these laws are subject to declaring void if they are inconsistent with the provisions of the Constitution, wholly or partly. Means if any act or any law is totally inconsistent with the constitutional provisions, immediately it shall be stand void. If it is not, then to the extent of that inconsistency, which means any section of that law, if that is not consistent with respect to Constitution, only that section will be considered void, not the complete law. Other provisions of law will stay, and only the part or the section of that law which is inconsistent with the constitutional provisions shall be considered void. So this is 13.1. 13.2 says, if state makes any law which takes away the rights conferred by the part 3 of Constitution, which is fundamental rights, so any such law made by state in contravention to part 3 fundamental rights shall be void. So this section 2 of Article 13, it clearly necessitates that state is not supposed to make any law which is against the right given by the part 3 fundamental rights of Indian Constitution. The case from Indian jurisdiction, you should remember for this part 13.2, one famous case is State of Punjab versus Dalbir Singh. It is AIR 2012 case, which speaks about this clause that any law which is made in contravention to part 3 of the Indian Constitution shall be void. Now section 3A and B of Article 13. Section 3A talks about what is law. For the clear interpretation of this clause, it says what law is. So the law is any ordinance, any order, any bylaws, rule, regulation, notification, custom, usage, which have the India as force of law. So 3A says about what law is. So these are all things what we discussed now and what we said now. These are considered to be the law. And it also incorporates one term which is saying having India as the force of law. So now what is the force of law? We have just discussed when we discussed the part 1 of Article 13, which is law in force. So law in force and force of law. The difference between these two is the force of law, which speaks about everything which is mentioned in Article 3A, means any ordinance, order, bylaws, rules, regulation, notification, customs, usage, etc. This all is considered as the force of law. While the law in force, which is 3B, we discussed, these are the laws which was passed by legislature in India just before commencement of the constitution and not previously repealed. So you should understand now that what is the difference between force of law and law in force. Force of law, whatever comes forward in the form of rules, regulations, ordinances, etc. While the existing laws, which remains unchanged with the passing of the constitution, which remains unchallenged with the passing of the constitution, they all is the law in force at the time of placement of constitution. Now the section 4 of article 13 says that nothing in this article, which is article 13, shall apply to any amendment of the Indian constitution made under article 368. So it's clearly said that this all story related to consistency of the existing law, law in force and force of law, this all is irrespective of any constitutional amendments which can be made under article 368 of constitution. Well, the same thing has been seen in the case of state of West Bengal versus Committee for Protection of Democratic Rights in West Bengal. This is a AIR 2010 case, and it was held in this case that the fundamental rights entrusted in Part 3 of the Constitution are inherent, and these cannot be extinguished by any constitutional or statutory provisions. So this was good to know about the Article 13 before we start from Article 14, because 14 to 35, as we said, these are six groups of fundamental rights. So before seeing that, we should know that what happens to those acts and laws which were available in Indian jurisdiction at the time of placement of constitution. So we have learned in this Article 13 that whatever laws were present before the enactment of constitution or at the time of enactment of constitution, those who were in accordance with the constitutional provisions remain unchanged. Like Contracts Act 1872, it was totally clear with respect to any conflicts or any inconsistency with Indian constitution. It remains unchanged, apart from some small changes which were done in the future, in the future or later course. While any other laws which were in contravention to constitutional provisions or which are having inconsistency with respect to Indian constitution, those were changed in due course, or that part of those acts was declared inconsistent or void at that time. Now, in view of Article 13, there are some doctrines related to constitution that we will discuss in the next part. Thank you.